Yes, Mr. Gibbon.
My Lords, my Lady, just before the short adjournment, I'd given you what I put forward as pointers as to why one was looking for two conversions rather than one. And obviously you have my submissions from this morning as to how the legislation operates coherently once you've identified two conversions. So, if you like, starting this afternoon, I begin by saying that, reliant on the language of Section 132, having two conversions, unaggregated conversions, is the more obvious choice. And if you're with me on that, one doesn't need to even get into a comparison with how aggregation of these securities would or might be inconsistent with the scheme of the legislation.
Are you going to deal with the question of attribution for value purposes?
Only briefly, to the extent that on the facts of this case, of course, the attribution is of no difficulty whatsoever. One's got bonds which are exchanged for an overall amount. There's no suggestion.
Market value of everything in this case.
There's a market value of everything.
It's attainable, but would that always be the case?
Wouldn't necessarily always be the case. And on our submissions, perhaps I'll get to that slightly further in, but in terms of how it would be done, my instructions are to the extent the Act wouldn't make specific provision, my clients don't envisage that there would be a difficulty if that is the correct overall thing, on the basis that the calculation element, the computation element, is subsidiary to the primary construction.
Let's carry out a valuation, however difficult.
What one would have a go, and there are clearly situations where that has arisen. But returning to where I was, as I said, to the extent that therefore one doesn't need to get to the comparison, that would be a place to stop. But if one does do the comparison, we respectfully adopt the comments of Lord Justice Floyd at paragraph 67 of the Court of Appeal, and that's at MS 112. So if one has identified two conversions, when considering whether it's the right approach, it's in my judgment legitimate to examine the impact of permitting the aggregation of fiscally different inputs on the operation of the scheme as a whole. And then he goes through what the consequences would be and then gives the quote from Jenks. Now, we respectfully say, looking at the Section 132 situation, that is a legitimate tool for the court, for the tribunal, because it is not imposing an impermissible a priori approach to the legislation, because one has already identified, we say, from the structure of the legislation that it is meant to tax non-QCBs and to free from tax QCBs. So we say in that context it is a permissible tool. And if the choice is simply, well, we actually could view this as being a single conversion, or we could view it as two, that would become a further pointer if one followed through my learned friend's arguments as to why one was tending to the two conversions. Now, I was going to move on to Section 127. To a degree, I'll be looking back occasionally to 132, but the essence, we would respectfully say, the essence of my friend's argument is that Section 127 envisages more than one asset on the input side. So, it appears to be said against us, if an aggregate conversion is capable of being identified for the purposes of Section 132, then that is what Section 127 will require. Now, as to that, HMRC accept that for the purpose of reorganisations under Section 127, there can be more than one class of share involved. And the Court of Appeal similarly took that view, and that's paragraph 64 in Lord Justice Floyd's judgment. Now, it doesn't follow from that that conversions which have already been identified as separate in accordance with 132 need to be aggregated. There's no such requirement, we would say, on either the language of 132 or 127. But, and this is where I look back to 132 somewhat, even if there were a doubt about that, the language of section 132, subsection 1, says that sections 127 to 131 shall apply with any necessary adaptations. Now, my friend's suggestion is that that simply denotes the mechanistic exercise of changing some words for other words. And in effect, he says they need to be treated as an aggregate under 127. Now, we say, with respect, that can't be right. The drafting of section 132, unlike many provisions in the tax code, it has elements of open texture to it. So, for instance, the definition of a security is an inclusive definition, which doesn't seek to say what every possible security is. And we also say, with any necessary adaptations, is a deliberate, or the phrase shall apply with any necessary adaptations, is a deliberate, flexible form of words, because what might be necessary in any given circumstance may be difficult for the draftsman to envisage. Lord Justice Floyd, for instance, made the observation which we adopt, that a reorganisation is very different to a conversion. And we respectfully adopt what was said by Lord Justice Lewison in this context. I perhaps should pause there to say that, of course, the context is that QCBs have throughout been part of the 1992 consolidation of the legislation. So digging back behind 1992 to see when they were introduced isn't, we respectfully say, a productive exercise. He expressly said at paragraph 82 how he considered apply with any necessary adaptations should be interpreted. That's page 115. The learned judge said this: section 132 applies sections 127 to 131 to conversions of securities with any necessary adaptations. Necessary for what? The answer to that question is, in my judgment, in two parts. One part is to make adaptations necessary to give effect to the policy underlying the Act as a whole, and in particular to that part of the Act which deals with corporate reconstructions. The other part is to make adaptations necessary to make sections 127 to 131 work in the same way as they work for corporate reconstructions. So, if you like, that includes the point my friend makes about changing language as necessary, but it allows you to step back further. And in a sense, the focus here is not so much on the changes in the words of 127, but it's really on what are you required to feed into 127 by 132. Is there some facet of section 127 which requires you to aggregate if you're not otherwise aggregating? And
you agree, it doesn't include section 116 in the purpose. And when he says the whole Act, I wonder what he was talking about, because it's quite clear that section 116 asks you to look at section 127 to 132 apart from this one.
My Lord, I'd respectfully adopt that. To the extent that it may look as though he was trying to say you can observe a purpose for the whole Act, that's quite a large statement. I suppose one could put it this very, very high level. The purpose of the Taxation of Chargeable Gains Act is to make sure that chargeable gains are charged to tax, but it's a largely meaningless
Doesn't advance matters very much.
So I particularly focus on what he says about this, if you like, this group, and I say by this group 132, 127, 116. And similarly, and this begins to get into a point I'll develop slightly more shortly. At paragraph 63, Lord Justice Floyd, and this is MS 112, makes the following point. as I've said, when applying Section 127 to reorganisations, to which that section applies directly, there is no difficulty with allowing aggregation of different classes of holding on the input side, because for tax purposes, all shares will be treated in the same way. In applying Section 127 to conversions of securities, however, it's not clear that it's justified to aggregate securities together when different classes of security will need different tax treatment. It's important to bear in mind that we are to apply Sections 127 to 130, and therefore the definitions with necessary adaptations. It does not follow, therefore, that one must simply substitute the word conversion for reorganisation wherever the latter appears. So we say that's consistent. Our primary focus is on what Lord Justice Lewison said, but we say that's consistent in expressing a caution about simply treating it as a mechanistic exercise. Now, that gets into my next point, which is, it was the Court of Appeal's further insight, consistent with the points already covered, that the input side of a reorganisation would always be shares, and it said they would be fiscally homogeneous. Now, my learned friend has given an example in his case of how that won't always be the case, and he refers to EIS. I mean, the short point from the revenue is we respectfully say that that doesn't undermine the essential accuracy of the Court of Appeal's insight, or indeed of any of the other reasons why Section 127 shouldn't require aggregation. And we particularly made the point at paragraph 40 of our case that EIS is essentially about the characteristic of the person holding the shares rather than the characteristic of the securities. As you've seen, the effect of 115 through to 117 is that the gain on the disposal of a QCB will not be a chargeable gain. So it's simply by reference to the nature of the instrument that tax allowance takes place. So finally, and again there's a little bit of an overlap, moving to what Section 116 says, we say that has a relevance to whether Section 127 requires aggregation. And we say that because of the definitional provision in Section 116, subsection 2. So references to a transaction include references to any conversion of securities, whether or not effected by a transaction, within the meaning of Section 132. So, in fact, we would say that sends you back straight to 132 to identify the conversion as being the transaction, rather than looking to what's been done at Section 127. So we respectfully say, based on that it follows that if you've identified two separate conversions for Section 132, there's no support for the analysis that Section 127 should somehow trump that by requiring aggregation. Now, there's then the question of...
Is it any more complicated than saying that if you look at 1162 and you ask yourself what would have happened to the component parts of what's said to be this overall transaction from a tax point of view, would a part of it have been separately taxed and dealt with as a separate conversion, then that, via subsection 2, answers the subsection 1 question.
With respect, my Lord, that's precisely the revenues point, yes. I've expressed it rather more lengthily, but
in other words, does one necessarily have to take a sort of holistic approach to Section 132 and say, well, it either always requires conversions to be looked at separately or never? You just ask whether this one would be.
Well, with respect, my Lord, I would agree with that, because it's not the revenues case that there can never be aggregations under 132. I haven't put the case that high. No. But what we're saying is, on these particular facts, how is Section 132 meant to work? Yeah. Well, it's got pointers in the direction of what you should be looking for, and those pointers are adequate, more than adequate, we say, on the facts of this case to make clear what the answer should be. to use an obvious point, on the question of aggregation, for instance, let's imagine you could have a loan note that's worth 10 million, or you could have 10 loan notes that are worth 1 million. Now, if you aggregate those 10, you can treat them separately. There's no particular need to treat them separately if plainly they can be dealt with in a way that's not contrary to the scheme of the Act. So the only caveat, if you like, is I think that, with respect, that the scheme of the Act will always be of relevance, because one shouldn't just look at Section 132 mechanistically, but subject to that, we will respectfully adopt your Lordship's analysis. Now, in relation to Section 1161B, if I ask your Lordships and your Ladyship to look at Lord Justice Floyd's analysis, and that's paragraphs 71 to 72, which are found on MS 113. Now, he essentially deals with Section 1161B as a drafting anomaly, and I respectfully say I can't really better what he says about it, namely that it's not determinative of the proper interpretation of the scheme, by which he's including obviously Section 132. He notes the pointers in subsection 3 and 4, but didn't regard them as determinative, not least because he thought, and this goes through to the top of page 114, that Section 1164 might itself throw up a further conundrum. So perhaps if I ask you simply
But there may be instances where the original shares do, in fact, consist of more securities than are capable of being converted into QCB, or...
But the focus of the comment in paragraph 71, my lady, was that the focus on, can you on the input side have QCBs and non-QCBs? And there was an attempt by the Revenue at the FTT to say, well, it might have been something to do with the transitional provisions in 1984, which the FTT wasn't persuaded of, and certainly I've not sought to repeat it since my involvement in the case. And I'm in the position that my clients can't ask you to find that there was a particular reason. We do say it's an anomaly that's been in place for a long time. In relation to my friend's points about Section 135 and 136 feeding you through 127 to 116, I've tried to take instructions in relation to that to see if there's anything more that can be said in relation to those. I'm told there have been no problems thrown up in that context that those behind me are aware of today, which is not a full answer, I'm aware, but as much as I can say on my feet. But we do respectfully say that the focus for this hearing is, as it's always been through the progression of the case, Section 132, 127, 116. And I've made the point already this morning, the fact that there are anti-avoidance provisions in 135 and 136 may mean that those academic questions in relation to those sections may never get to be asked in a tribunal. So that is what is said by the by Lord Justice Floyd in the Court of Appeal. Now, Lord Justice Lewison does appear to go further. Now, it's not an express difference of opinion with Lord Justice Floyd and Kitchen. Lord Justice Lewison says he agrees with Lord Justice Floyd, and Lord Justice Kitchen agrees with both. But if you look through to paragraphs 88 to 89, that's MS 115 to 116, he appears to go further, and you'll see that in particular in the middle of 89. And he says that essentially, if push came to shove, he considers section 1161B ought to give way. And he says, I consider the approach described in Luke, and that's about avoiding unreasonable results, enables us to disregard the phrase or include in the circumstances of this case. Now, as to that, my first submission is that appears primarily to be a commentary on the FTT decision rather than part of the ratio. And secondly, while one can see how the view arises, it's not necessary to go that far to decide this case.
One can decide it on the basis of necessary adaptations.
Indeed, two conversions, because if it's two conversions and they're not trumped by necessary adaptations, to turn it into an aggregation of the two conversions. So that's to amplify your lordship's comment, but yes. And in a sense, that comes back to the point I've already made, which is so far as possible, one is identifying unmixed conversions. And my Lord Briggs has already spoken about that. So with that background, I was simply going to move on to the third of my main headings, which is, well, what is the relevance of the documentation?
Are you able to help us at all about subsections 3 and 4? I mean, as I understand Lord Justice Lewison, the point is that the application of 116 depends, the way it actually deals with gains depends on there being what's termed an old asset and a new asset, and the way in which those terms are defined assumes that that you don't have mixed inputs or outputs.
On the output side, I think it was I respectfully submit, it was the view that clearly that there must be the possibility of a mix on the output side, but he was focusing on whether there should be a mix on the input side. And that was where the comments of Lord Justice Floyd perhaps identified a certain difference of emphasis between him and Lord Justice Lewis, and that's paragraph 73 on page 114, because he points out that if you treat constitute...
And the same expression is used for both the input side and the output side.
It is, and that's why Lord Justice Floyd said, I think ultimately because that may cause a further anomaly, I'm not sure I get any greater assistance overall to the assistance reach. And he didn't feel it was necessary to go so far as to say the words or include in this context should be excised. Mm. So that's why I submitted that it seemed to me that Lord Justice Lewison's going slightly further wasn't part of the ratio, but was more in the way of a commentary on the FCT's decision, i.e. if one had to make a choice, he thought they made the wrong one. Don't pin my colours to what Lord Justice Lewison said, though I do respectfully say one can see how that result is reached. But I prefer to focus primarily on starting at section 132 and going to 127. So unless there were further questions on that, I was simply going to turn briefly to the question of the documentation and the relevance of that. Now, it's been a substantial plank, clearly, of Malone and Friends' arguments throughout the process of this case, that the agreement entered into by his clients on the 7th of May 2003 was a single transaction. Now, he said in his case that he accepts that's not determinative, but he also goes on to say that on the fact there was indeed a single transaction. So I am going to proceed on the basis that he says it's an important part of the way he puts things. It's a single bargain in a single document. And they therefore say the gateway into section 116 isn't met. Now,
Single contract
it's a single
not
contract.
necessarily mean the same thing as a single transaction.
Yeah.
We say, with respect, that it would be very surprising if the proper interpretation of the relevant legislation was that a decision by a taxpayer to use a single document should have the consequences that my friend puts forward. And I make a number of points in relation to that. First, as a general point, why should the legislature have deliberately so provided? We say it would need clear words. Secondly, no such clear words commanding one to look at a document or look for a document are found in section 132. One is simply instructed to look for a conversion of securities. Thirdly, and you've seen this from our case, we respectfully say that the use of a single document proves too much because, of course, in my learned friend's case, there are two transactions because he's got two clients who've had their securities processed through that particular document. Fourthly, the suggestion that form could override that analysis got short shrift in the Court of Appeal, and in particular, that's Lord Justice Floyd at paragraphs 76 to 77. And my last point in relation to it is that we respectfully say this isn't HMRC artificially splitting the Hancock's transaction. It is HMRC and the courts not being distracted by the form of the document used from the question of what conversion has taken place for the purposes of section 132. So that's what I wanted to say in relation to the use of the documentation. And beyond that, simply to finish by the 3 points which you've seen in my written case, we say that the interpretation reached by the Court of Appeal and recommended to you by HMRC is principled because one can reach it by orthodox methods of interpretation without straining language. It's fair, secondly, between taxpayers generally and fair to these taxpayers. They're only taxed on the gains which they made on their shares. And we also say it's coherent in the sense that the scheme works correctly if you identify the two conversions in accordance with the manifest purpose which has been identified not least in the Jenks case. So those are my submissions.
Thank you very much. Ms. Wilson, do you follow? Mr. Sherrier?
My Lord. I think you've already got some of these points, so I'll try and be as quickly as possible, just making sure that they're there. My learned friend took you to the discussion of general principle and how that could be applied. And obviously, at the highest level, any taxing statute is about tax, raising taxes. In the context of what we're looking at here, Section 126 through to 136 is about treating particular transactions which would otherwise give rise to disposals as not doing so. And it's not a relief claimed. Those provisions apply or don't apply, with the exception of 135 and 136, which are disapplied, no choice, if you fall within the anti-avoidance provision of 137. And 115 says that QCBs will be tax-free. There'll be no chargeable gains on disposal. So if we're looking at the approach to this, then the taxing provision is 116. And the starting point is, well, does 116 do its job? And I accept that raises a question about, well, how has 132 applied, and is it one or two conversions, and does that mean it's one or two transactions for the purpose of 116? Secondly, to pick up the last point my learned friend made, or the last topic, we do not rely on the form of the transaction alone in terms of it being in one document. It is, but that would not be determinative. We accept that. It's an aspect of all the other bits. It was one deal, it was one agreement, commercially covered a number of things, yes. And what it gave rise to was an undifferentiated giving up of the old securities and the acquisition in each case of each taxpayer of one new security. So we say that's aptly described not only as one transaction, but one conversion as a matter of fact. My learned friend said that we had not made any general submissions on the purpose of the legislation, and I readily accept, subject to what I've said a moment ago, we've not done that because it's plain that what Parliament certainly had in mind with 116 was crystallising, or at least computing certain charges and postponing their crystallisation. What we've said is that for the court to assume that that's meant to apply to everything, you've got to find that in the words, and we say, for the reasons you've already had, particularly the different categories which fall outside 1161B, that's not there. The purpose at that lower level of application has to rely upon the words used. When looking at paragraph 71 of Lord Justice Floyd's decision in judgment in the Court of Appeal onwards, and the reference to an anomaly there, the anomaly which Lord Justice Lloyd was identifying was that the word include, at least on the input side, would have no application. And that was the anomaly. He was saying, well, I don't know why it's there, but he described it as an isolated anomaly in the passage in paragraph 71 at MS 113. But for the reasons I explained earlier, in particular the way in which the application of the charge in sub 9 and sub 10 depends upon the structure, it isn't isolated. And we say it's not anomalous. Insofar as my learned friend says the open texture of 132 leads one, when making necessary adaptations, to have a wide or wider approach than simply making those alterations that are necessary to give effect to 127 and following in the context of a conversion rather than a reorganization or exchange or reconstruction. We say, well, it is maybe flexible, but the point, the policy of the provisions is to avoid disposals and to have this single asset fiction. That's what 127 is all about. And it's obviously looking at outputs as well as inputs, but we say if there is a degree of flexibility, it points at drawing transactions which can be brought into that, because that's what Parliament wants to happen. It wants it to be simple. Where there's a mix-up on the way in and the way out, pull it all together, treat it as one. So we say if there is any flexibility there, it points to a single conversion treatment. Certainly one process. Just a point to note, my learned friend took you to Lord Justice Lewison's judgment at paragraph 82, and if I can just turn it up at page MS 115. This is where Lord Justice Lewison asked the question, necessary for what? The answer to that question, in my judgment, is in two parts. One part is to make the adaptations necessary to give effect to the policy underlying the Act as a whole, and that clearly has to do with the policy underlying those provisions in Part 4, Chapter 2, which are in point. And in particular, to the part of the Act which deals with the corporate reconstructions. The other part is to make necessary adaptations to 127 to 123 work in the same way as they work for corporate reconstructions. And just to note, I don't know whether it's a slip or a typo, but it, of course, 127 to 1330 in their simple unadapted form apply to reorganisations, not reconstructions. So I don't know whether His Lordship was using reconstructions in a loose way to refer to all the sorts of transactions that might fall within Chapter 2, Part 4 through to Section 135 and 136, or whether he was deliberately referring to reconstructions, or whether it's a slip, and I don't make it much more of it than that. But I say it doesn't take us any further if we read in their reorganisations, because we know the purpose of the necessary adaptations, which also applies for 135 and 136, is the same throughout. The policy of Parliament is clear. And I've already given it to you. An example was given of a 10 million loan note or 10 1 million loan notes, and it was said, well, if they're all QCBs or they're all non-QCBs, it doesn't much matter whether you treat them as 1 or 10. Well, with respect, I think that is perhaps a speculative observation, because you'd want to know what was going on the other side of the transaction, and whether or not having this treated as 10 transactions might mean that you've got 10 new assets, and that when you make a disposal, are you making a rateable disposal of each of the 10 new assets, or of asset number 1, and that might affect the quantum of charge that comes in. Maybe not.
You could pool them.
It's not clear, my lady.
There's no more general provision in the 1992 Act?
The pooling provisions which apply in certain circumstances depend upon when you acquired the asset in question. So if you have a 1982 pool which deals with acquisitions made prior to the 1982 revaluation date, then you have a period of indexation, and you have different rules applying to acquisitions between 1982 and 1997. Then you have new rules after 1997 during the taper relief period, because you were always counting the period of time that you'd held the asset. Then you get the abolition of taper relief, and that no longer matters, and you're back to simple pooling. So that's with chargeable assets, which fall within Section 106 and those subsequent provisions. It's not clear how they would, to me, without reflecting at some length, how they would necessarily apply in quite the same way to gains which arose on a chargeable asset, but which had been subject to Section 116 when the original chargeable asset had been replaced by a QCB at a later date. So this is not simple. It's difficult. Mm-hmm. My learned friend said the revenues focus. He said the focus throughout this case has been on Section 132 and not 135 and 136. And I would respectfully say that that's been the revenues focus throughout. And whilst our references to 135 and 136 have taken a sharper focus in before your lordships and your ladyship, the scheme of Chapter 2 has always been part of our argument, for what it's worth. On the question of subsections 3 and 4 and the word constitute, which, my Lord Carnwath, you put question to me this morning, I would only observe at this stage that there is another oddity here. So subsection 1 refers to original shares and new holding as having the same meaning as they have for the purposes of 127 to 130, which therefore contemplates the possibility. So we're at MS 481. Divider 4 in Authorities of Volume 1. So the last couple of lines, the last penultimate line of subsection 1, in paragraph B above, the original shares and the new holding have the same meaning as they have for the purposes of 127 to 130. So that's addressing the question of the consists or includes, possibly. And subsections 3 and 4 talk about the circumstance where the QCB would constitute the original shares for the purposes of 127 to 130, or in 4 would constitute the new holding. So it may well be that that is simply explained as referring to those particular circumstances, but not giving a general definition for new asset, and where it falls within either 3 or 4. It's, as we said,
It's consistent with the Court of Appeal's interpretation.
Well, we say it's consistent
With yours?
with ours because of the words at the end of sub 1, and sub 3 and 4 just deal with particular cases which fall within sub 1, which again we say is consistent with our interpretation of sub 1b.
Yes, of course. Thank you.
My lady.
And what happens to cases falling within 1B which are not within 3 or 4?
Well, we then are taken to see whether or not, well, they still clearly, well, I think one has to then look down at 5 and decide whether or not the reference in 5 to the new asset is aptly read as really referring to the new holding referred to in subsection 1. And if that's the case, then that takes you through, and we wouldn't argue against that, that takes you through to subsections 9 and 10, and they would operate naturally on that same interpretation. If not, then there's a possibility this provision's misfired again in the charging words. You were taken before the short adjournment to Billingham and Cooper, and I'd simply remind you of the passage in Inco Europe that I took you to this morning. I think the principles are clear. We're arguing about how they apply to these particular provisions. There is, I think that's all the points that my learned friend raised. There was a point, my lady, that you raised before the short adjournment towards the end of my submissions concerning the provisions in subsequent parts or in subsequent sections of Part 4. In particular, there are a series of provisions dealing with transfers or division of UK businesses involving more than one member state. There are provisions which deal with the transfer of a division of a non-UK business and so on. We've identified a few provisions there. We're agreed that so far as we can tell, we don't think there's anything in those provisions which makes any difference. But for what it's worth, section 140 capital D capital A sub 2 treats certain of those transactions as reconstructions within section 136. Doesn't say anything about how it operates, it just brings them in. They wouldn't otherwise. And then the similar provision in 140 capital G in relation to mergers which fall within similar E-wide UK and non-UK circumstances. But it doesn't inform the decision. The other references to the provisions we've been concerned with, in 140H, there's an extension of the meaning of company for the purpose of share exchanges to an entity listed in the Mergers Directive. And in section 151 capital BB and capital BC, there are provisions relating to community investment tax relief, which we don't think are of any relevance. All of those provisions were enacted after the events that we're concerned with. So you'll find them in the current...
But isn't it possible Parliament in 116 could have wanted to make it as flexible as possible to allow for all the permutations that might conceivably arise? I mean, just another possibility. But but I think the point is simply, from what you've given us, that there are other instances where those four sections, 127 to 131, are incorporated into another type of relief in the context of QCBs within Part 4.
I wouldn't disagree with the overall idea, my lady. I think I would put it slightly differently, that other transactions are brought within the definitions of 135 and 136.
Okay, thank you.
Other than the ones that we talked about this morning. Unless there's anything else on that your lordship requires, or generally, my lords.
I think not, Mr. Sherry. Well, we're very grateful to both counsel. May I say, we're particularly grateful for the fact that the written cases in this appeal were relatively brief, but did full justice to the arguments nonetheless. And we're grateful to those sitting behind who also contributed to the preparation of the appeals. It's obviously a tricky problem. We'll let you have our decision in due course.